Hello, students. I welcome you all to lecture number one of Sale of Goods Act 1930, which is also known as SOGA in the short form. This is a lecture series of CA Foundation lectures sponsored by Sri Jayendra Rankson. I'm your mentor, Shekhar Gehlot. Okay, so Sale of Goods Act. Just like the name suggests, in this act, we are going to study or we are going to understand how transactions of sale and purchase take place in India and what are the regulations. Okay, what are the regulations over it? Okay, sale of goods is one of the specific form of contracts recognized and regulated by law in India. Definitely, a sale is a contract between a buyer and a seller. Sale is typical bargain between the buyer and seller. The SOGA allows the parties to modify the provisions of the law by express stipulations. However, in some places, this freedom is severely restricted. So now, what does Sale of Goods Act do? It provides freedom to buyers and sellers to tweak and to twist the provisions of Sale of Goods Act as per their own situations. Okay, as per their own customary situations. But in some cases, this particular freedom is severely restricted. We will, as we'll proceed ahead, we'll read what are those changes which can be made and what are those restrictions which are severely restricted. Sale of Goods Act 1930 is an act to define and amend the law relating to sale of goods. This is the preamble of the act. It gives an introduction about the act. Okay, that what this act proposes to do. This act proposes to define and amend the law relating to sale of goods act. It extends to the whole of India except the state of Jammu Kashmir. This is the earlier position. Now it extends to state of Jammu and Kashmir as well. It came into force on 1st of July 1930. Now, okay, from year 2019, after the removal of Section 3, Article 370 protection granted to state of J&K, now all central laws, including this particular Sale of Goods Act, is applicable to state of Jammu and Kashmir. In fact, I should not be calling it a state of Jammu Kashmir anymore because now it has become a part state and part union territory. Now it is a totally different concept. Okay, so this is the overview of the unit. What are we going to study in this particular unit? We are going to study about contract of sale and how a contract of sale is made. What are the stages? There is an agreement. Okay, there is an agreement. Initially, agreement is between definitely a buyer is there and then seller is there. Then after agreement, what happens? A transfer of property will take place. Okay, either it will be immediately transferred or it will be transferred on a future date. Then what are the goods involved in the transaction of sale? Goods can be existing goods, future goods, contingent goods. Okay, and then existing goods are further categorized into specific, ascertained, and unascertained. Then, when you have agreed to transfer the property, what is the property? Goods. What kind of the goods? Either any kind of these goods. Okay. Then you come to price. What is the price which you should pay or one should pay for buying out these goods? Okay. What is the price? Then there is price. How price is to be formulated. Then the essentials of a valid contract. It is a contract. Okay, it is a contract between an agreement. It's a contract between a buyer and the seller. Therefore, it has to fulfill all the essentials of a valid contract. Okay, it has to fulfill all the essentials of a valid contract without any fail. Okay, this is the overview of what we are going to study. Now the chapter begins with definitions as any other act. Okay, so whenever we discuss any particular act, every act, like in the case of Indian Contract Act as well, we begin with the definitions because this is the first step in understanding an act. Okay, how it defines certain provisions, how it defines certain terms and conditions, terms used in act later on, so as to remove any ambiguity or any vagueness, so that there may not be two or three meanings of one word. Whatever the meaning of the word is ascribed by the act, we have to restrict it to that sense only. The first and foremost definitions are of buyer and seller. Okay, so definitely, what is a buyer? It says buyer means a person who buys. Buyer means a person who buys or agrees to buy goods. Agrees to buy goods. Okay, buys means present buyer. Who's buying hand to hand? Just like I go to a shop and I tell them that give me a register. They give me a register. I give them 20 or 30 whatever rupees. I become a present buyer. I have bought the goods then and there itself. Then agrees to buy. That means I will buy on some other date, on some next date. That is, I am a future buyer. I will buy on a future date. Now there is a change in the farm laws. Now the farming laws. Now the government has permitted future contracts in the crops as well. Now the government say that farmers can sell their crops in advance, even before the plowing, even before the sowing of seeds. Okay, they can do that. In that case, anyone who goes to the farmer to procure its crop on a later date will be categorized as a future buyer, and the farmer will be a future seller. So buyer, the term buyer includes both someone who's buying today, who's a present buyer, as well as someone who's a future buyer. Okay, so the date of purchase is immaterial. What is material for being a buyer is intention to buy. If you have an intention to buy, you will be a buyer. Either you buy it today or you buy it tomorrow. An intention has to be a crystallized, clear intention. It should not be that whether to buy or whether not to buy. It should not be like this. If you have a clear intention that you have to buy, then you will be a buyer as per this particular act. Seller means a person who sells or agrees to sell. It also mean it again means same thing. Seller is someone who is selling right now or who agrees to sell. Okay, okay, who agrees to sell, like a farmer. He agrees to sell his crops to someone, to some company or to some dealer. The two terms buyer and seller are complementary and represent the two parties to a contract of sale of goods. Both the terms are, however, used in a sense wider than their common meaning. Okay, they are terms used in wider than their common meaning. Okay, because in common meaning, we all understand, in common parlance, we all understand someone who's buying at the present or someone who's selling at the present as a buyer and seller only. Okay, we don't see someone who's going to buy or who's willing to sell at any future date as a buyer or seller. Okay, not only the person who buys but also the one who agrees to buy is a buyer. Okay, that means even someone who is agreeing to buy, who agrees that okay, I'll buy it on some other day, he is also considered to be a buyer. That is a wider definition. Narrower definition used in the common parlance, in the common day-to-day affairs, is when you agree to buy on, when you are buying, when you are actually buying, or when you are actually selling. Similarly, a seller means not only a person who sells but also a person who agrees to sell. So, seller is also a person who has agreed to sell. goods and other related terms. Now we have understood buyer and seller. Now we'll proceed to some other definitions. Okay, other definitions attached with the sale and purchase. Okay, the first one is going to be goods, because we are going to, this act deals with sale and purchase of goods. Okay, goods means every kind of movable property. So let us read it till here only. Goods means any kind of, every kind of movable property. Now, movable property here means, it means act. First of all, first connotation of this definition is, the moment you read it, first connotation which will come to your mind is goods, that the act deals with only movable property. It does not deal with sale and purchase of immovable property. I should not write goods here, I should write property. Okay, because goods are always movable. Goods are always movable. Goods are always movable. Whenever the term goods is used in respect of anything, you first understand that this thing, that thing is going to be a movable property. Okay, it's always a movable property. It is never an immovable property. An immovable property can never be characterized as a goods. It is going to be called as land or some other thing, but definitely not a movable property. So goods means every kind of movable property other than. Okay, now this is the exception. So it says, generally it says every movable property is going to be considered as a good. Okay, except, except, other than means except actionable claims and money. Actionable claims and money. Actionable claims, what are actionable claims? These are promissory notes or checks. These are promissory notes or checks or bills of lading, etc. like this. Actionable claim. Okay, claim means you have a right. Actionable means you can bring an action. Okay. Okay, something over which you can bring an action upon court. Okay, you get a right. You have a claim over that action. You can claim that action. Okay, promissory note. If someone promises you that I have, if someone gives in writing that I have to pay to Sham 200 rupees, then that is a promissory note, and he can definitely take that promissory note and go to the court. That, see, this guy has given me in writing, and now he is refusing to pay 200 rupees. Now it is an actionable claim. Checks, you hand over a check to someone, you fill a check and hand it over to someone. Now this guy has a right to use that check, and if the check bounces, if the check is dishonored, he can definitely go to the court. Bills of lading. Bills of lading means when you are transacting through ships. Okay, when you are sending your consignments through ships or aeroplanes or some trucks, you get a bill of lading. That means you have loaded the truck with the articles. Okay, you get a receipt that you have put 1 ton of wheat in the ship or plane or the truck. That is a bill of lading. Okay, that also gives you an action. Tomorrow, if your product is not delivered, you have an action against the consignee. Okay, not consignee, against the delivery provider, delivery service provider, that I had loaded something with you. Now, where's that thing? Okay, now that is an actionable claim. So actionable claims are not treated as goods. Okay, so the sale of purchase of promissory notes or checks or bills of lading, yes, they can very well be sold in the market and purchased as well, but they are not covered under this Sale of Goods Act. Here we are dealing with only with commercial goods. Okay, commercial goods, not actionable claims or money. Money is not a property at all. First of all, money is not a property. That is why it is not included in the definition of goods. Money is not a property. That is why it is not included in the definition of goods. And and now this exception part, from starts from other to money is over. Now read it like this: money, goods means every kind of movable property and includes stock and shares. So whatever stock you have, okay, stock means whatever you have in your go down, or shares, or you have bundle of shares with you. Stock and shares. Shares are, yes, shares are very much defined as goods. Okay, so you can buy and sell shares on online platforms or on the site of NSE or BSE. They are goods. Growing crops. Okay, growing crops. So the crops which are growing right now, they have not grown. Okay, they are yet to be harvested. They are growing crops. They are goods. Grass. Okay, and things attached to, or forming part of land. Anything which is attached to the land or it becomes a part of land, like a tree, a standing tree. Okay, a tree, a timber tree is standing, it becomes a part of land. Okay, it forms a part of land, or it is even attached to land. Okay, or a generator which has been attached to the ground. Okay, a heavy generator, heavy load duty generator attached to the ground, or a tree which it definitely becomes a part of land, which are agreed to be severed before sale or under the contract of sale, which are agreed to be severed before sale or under the contract of sale. So something which is attached to the land, it may be growing crop, grass, or things attached to or forming part of the land. Okay, these things, when before the contract of sale, before the sale or under the contract of sale, it has been undertaken by the seller that yes, I will sever it, I will detach it from the ground and sell it to you as a movable property, it will be considered as a good. Okay, so this is a very wholesome definition of a good. What is good? Okay, so let's read it again. Goods means every kind of property, every kind of movable property other than actionable claims and money, and includes stock and shares, growing crops, grass, and things attached to or forming part of the land, which are agreed to be severed before sale or under the contract of sale. This definition is a wider definition than contained in the English law, which does not consider stock and shares as goods. Okay, this is a wider definition than the English law. English corresponding law of the Sale of Goods Act, it does not consider stock and shares as goods, though it includes a ship. Okay, it includes a ship. We do not include a ship as a movable property because it is permanently attached to land. Okay, it is permanently attached to land. Yes, I know it sails in the water, but water is always attached to land. Actionable claims. Now it also defines what are actionable claims. When it excludes something from the purview of being called as a good, then it defines that particular thing as well. Okay. Actionable claims which can be enforced only by an action or suit, like a debt. Okay, actionable claims are which can be enforced by an action or suit, by an action in the law. Okay, it's called suit. I'll sue you. You must have heard this term. I'll sue you. That means I'll file a suit against you in the court of law. Example is debt. That means you have to repay someone. Okay, promissory note. What is promissory note? Promissory note is a debt. What is check? Why will you pay someone a check? Why will you hand over a check to someone? That means you are paying him. You owe some money to that person. Example is debt. A debt is not a movable property or goods. Okay, a debt is not a movable property or goods. It is simply a claim. Okay, it is simply a claim in the law that you can claim that particular amount from this person by going to the court. It is not a property. It is a claim. It is merely a right. Like I have a right to vote. Okay, I have a right to vote. That is not a good. That is merely a claim that tomorrow, if the returning officer does not allow me to vote, I can file a claim that he did not permit to vote. I have a right to vote. That is a claim. Okay, that is not a property. So, actionable claims like debt, promissory notes, checks, bills of lading, money, etc. They do not become a property, they are always a claim. Even the fixed deposit receipts FDRs are considered as goods under Section 176 of Indian Contract Act, read with Sales of Good Act. But we consider fixed deposit receipt FDRs as goods. Okay. Now this is a flow chart of goods, a definition of goods in a concise manner. Goods means every kind of movable property. First part. Second part is exception, except actionable claims and money in circulation. Also includes stock shares, growing crops, grass, and things attached to or forming part of the land which are agreed to be severed before sale or under the contract of sale. Now let us do classification of goods. Now we are reading goods. We are trying to understand the definition of goods. So we must understand it in a wholesome manner. So what is a good? We have not done. What are the classifications of the good? Okay, first goods we have done the definition. What are the classification of goods? How we can categorize the goods? Goods can be further categorized as existing goods, future goods, contingent goods. Okay. Now, what is existing goods? Existing goods again can be declassified into three subcategories, that is specific, ascertained, and unascertained. These are further three subcategories of the goods. Now, let us understand all of them one by one. Existing good. What is an existing good? By the name, it suggests that something which exists right now. Okay, existing means which is in existence. Which is in existence are such goods as are in existence at the time of the contract of sale, those owned or possessed by the seller at the time of contract of sale. Okay, now when I go to a TV shop. Okay, I go to a TV shop. I tell him that I want a LCD or LED 50 inches LG. He says I have it. That is an existing good. Okay, that becomes an existing good. But if he says that I'll have to order it, you wait for 2 days, it will lose its category of existing goods because it is not existing. It is not owned or possessed by the seller at the time of contract of sale. Okay, but after 2 days, when I'll again go back to that seller and he has those goods, then this good will become a existing good. Okay, the TV will become a existing good. Specific goods. Now, specific goods. Specific means something which you have identified. Okay, the term specific stands for something identifiable. Specific means identifiable. Okay, identifiable. Specific goods means goods identified and agreed upon at the time of contract of sale is made. Okay, agreed upon, and identified. Suppose A goes to A goes to purchase 40 bags of sugar at B's godown. Now B in his godown has B has 100 bags of sugar, all having same quantity. Okay, all having same quantity and the same grade of sugar, same type of sugar, the one which is B, which B is looking for. In this case, what B will do? B will Okay, so what B will do? B will put a mark on all 40 bags of his choice to identify it from rest of 60 bags. Now these 40 bags of sugar which he has identified, on which he has put a mark, will become specific goods. They will become specific goods, okay? Because specific goods means goods identified. Now he has identified those 40 bags and agreed upon at the time of contract of sale is made. Now B has agreed that okay, whatever bags you have marked upon, I'll sell you those 40 bags. These are now specified goods. Specific goods, sorry. Now let's do some example. Example 1 is any specified and finally decided goods like a Samsung Galaxy 7 Edge, Whirlpool washing machine of 7 kg, etc. This will become a specified goods, okay? It is not like I want to buy a Samsung phone or a Whirlpool washing machine. No, Whirlpool may be having hundreds of the models in washing machine, Samsung may be having so many other phones models, but you want Samsung Galaxy S7 Edge and you want Whirlpool washing machine of 7 kg capacity. Okay, therefore now these goods are specific goods. Example 2. A had 5 cars of different models. Okay. He agreed to sell his Fiat car to B and B agreed to purchase the same car. In this case, the sale is for specific goods as the car has been identified and agreed at the time of sale of contract. Now A has 5 cars. Now if B says I'll purchase one of your car, okay, and he says okay I'll sell you one of my car. Now there's no identification right now. Nobody knows which car is being talked about here because A is having 5 cars, okay. But now A says I'll sell you Fiat car, B says okay I'll purchase Fiat car. Now the Fiat car, because now it has been identified, it becomes a specific good. Ascertained goods. Ascertained goods are those goods which are identified in accordance with the agreement after the contract of sale is made. This term is not defined in the Act but has been judicially interpreted. In actual practice, the term ascertained goods is used in the same sense as specific goods. Okay, so this term ascertained goods has not been defined in the Sale of Goods Act. Why? Because it means the same thing as a specific good. Ascertained goods means which you have ascertained that these are the goods which you have identified. Okay, so again, it's a synonymous with the specific goods. When from a lot or out of a large quantity of unascertained goods, the number or quantity contracted for is identified. Such identified goods are called ascertained goods. Okay, when you out of a lot you identify something, just like we understood in this particular example, out of 100 bales he identified 40 bags. Now these 40 bags will become specific goods, or you may even say that they have become ascertained goods. A wholesaler of cotton has 100 bales in his godown. He agrees to sell 50 bales, and these bales were selected and set aside. On selection of the goods become on selection, the goods become ascertained. In this case, the contract for the sale of ascertained goods as the cotton bales to be sold are identified and agreed after the formation of contract. It may be noted that before the ascertainment of goods, the contract was for the sale of unascertained goods. Okay. In this case, what is happening here? The contract of sale comes up before ascertaining. Okay, he contracted that I'll buy 50 bales of cotton and he agreed that I'll sell you 50 bales of cotton. Now contract is complete, but nobody knows what 50 bales. Okay, he has 100 bales. Now what 50 out of those 100? Now he'll identify his own goods. Now during the time of the contract of the sale, they were unascertained goods. It was a sale and purchase of unascertained goods. Okay, goods were definitely identified. Definitely they know that they are going to transact in cotton bales. But what cotton bales out of those 100? Now it becomes ascertained only after the contract is entered. Unascertained goods, just like we discussed, ascertained goods are specific and identified goods. Unascertained goods are those which are not specifically identified or ascertained at the time of making of the contract. They are indicated or defined only by description or sample. They are indicated or defined only by description of sample. I want 100 kg, I want 10 bags of this particular basmati rice, or I want 100 bags of this quality of wheat. But what 100 bags? You are having 1000 bags. Give any 100 you want to. Give any 100 you want to. Okay. That is unascertained goods. Example, if he agrees to sell to B one packet of salt out of a lot of 100 packets lying in his shop, it is a sale of unascertained goods because it is not known which packet is to be delivered. As soon as the particular packet is separated from the lot, it becomes ascertained or specific goods. Very simple. Now we have something called future goods. Okay. Future goods means goods to be manufactured or produced or acquired by the seller after making the contract of sale. A contract of sale of future goods is always an agreement to sell. It is always an agreement to sell. It is not a sale. Okay, sale means something which is concluded. I go and buy a register, I pay him money, and I get the register. Sale is concluded. Okay, the property is, what is the property? Property is register. Register has changed hands. Changed hand means earlier it used to be with the seller, now it is in my possession. That sale is concluded. But let us take the case of farm bills now, because farm bills is too much into limelight nowadays. So I go and enter into contract with the farmer that you are growing 2 3 acres of field for wheat. Once your wheat is harvested and ready to be taken off the land, then I'll buy them. I enter into contract and I'll pay you this much price. And he also agrees that within 3 months my crop would be ready to be harvested. Now this is a future good because right now seller is not having those goods. Right now seller is not having those wheat in a ready and deliverable state. He has a growing wheat only, not a final product. He doesn't have a finished product. Okay, so that means now in this case, this wheat will become a future good. Future good means goods to be manufactured, which are to be manufactured. Okay, I'll give a I go to a car seller. I want to buy a car. Car seller will say, okay, we'll deliver you within 2 months. That is the delivery time. What are they doing within these 2 months? They are manufacturing a car for me on my order. Okay, the cars are manufactured on order. They are manufacturing a car. That means it is going to be manufactured upon my order. Now the car will become a future good. Okay, because it is going to be manufactured or produced or acquired by the seller after making the contract of sale. Example, 100 quintals of potatoes to be grown on A's field is not illegal, though the actual sale of future goods is not possible. This is an example of sell, agreement to sell. Now, this example is an outdated example. Now, this actual sale of future good is possible. Okay, sorry. What they are saying is actual sale of future goods is not possible. Actual sale mean at present the actual sale of future good is not possible because future goods are always going to be sold in future. So actual sale at present is not possible. This is an example of agreement to sell. Okay, because it is going to be sold on a future date. P agrees to sell to Q all the milk that his cow may yield during the coming year. This is a contract for sale of future goods. Contract for sale of future goods. Example 3. T agrees to sell S all the oranges which will be produced in his garden this year. It is a contract of sale of future goods amounting to an agreement to sell. So, whenever we are going to deal in existing goods, it will always be a sale or it may be an agreement to sell as well. But most of the cases, it is a sale because when you go and transact in the future goods, you pay the price, you take the existing goods, you pay the price, and you take the goods. That's it. But a future good, you can never ever go and take the delivery then and there only. You'll have to definitely wait. Time span may differ. It may begin from as low as 30 minutes and go as high as your imagination. Okay, so existing goods always mostly it is a contract of sale. It is a sale. Existing goods is mostly sale, and future good is mostly, not mostly, always and compulsorily it has to be an agreement to sell. It has to be an agreement to sell. contingent goods. Okay, goods which are contingent, the acquisition of which by seller depends upon an uncertain contingency, are called contingent goods. Okay, contingent means it is a category of future goods which seller doesn't know whether he'll have it or not. Okay, seller doesn't know whether he will have that good or not in a future date. It is contingent, it is dependent upon. Contingency means, contingent means dependent. Contingent word means something which may or may not happen. Okay, it is dependent upon happening or non happening of a future event. Okay, acquisition of seller, acquisition of which by seller depends upon an uncertain contingency, are called contingent goods. Let's do, okay, we'll do the example later. Contingent goods are also, contingent goods also operate as an agreement to sell. Definitely, there cannot be a sale at all. There can never be a sale in contingent goods. It's always going to be an agreement to sell. Okay, sale is something which is done in the existing goods then and there at the moment. Okay, but any sale which is going to take place after some time. Okay, time may be within some hours or some months or some days, some weeks, some months or some years, that is going to be a agreement to sell. So contingent goods also operate as an agreement to sell and not a sale so far as the question of passing of property to the buyer is concerned, because passing of the property will not take place on existing date. In other words, like future goods, in the case of contingent goods also, the property does not pass to the buyer at the time of making the contract. At the time of making the contract, the property does not pass to the buyer. Example, A agrees to sell to B a Picasso painting provided he is able to purchase it from the present owner. This is a contract of sale for contingent goods. Now A agrees to sell to B. A says that tomorrow or some other day I will sell you a Picasso painting provided if I am able to myself buy it from the present owner. Okay, or another example may be, a farmer agrees to sell 100 kg of rice on a future date if it rained well. Okay, because rice is a very water hungry crop. It takes a lot of water, okay, to cultivate rice. Oh, so, yes, to cultivate rice. So largely a lot of farmers depend upon the monsoon. So farmer agrees that okay, I'll sell you 100 kg of rice, but if only it rains well. If only it rains well. If it doesn't rain well, I could not be able to supply you rice. That is a contingent contract. It's happening in the future date and it's contingent upon happening of the rain. If it rains well, then only the contract will be performed. If it doesn't rain, I will not be able to supply you 100 kg of rice. A agrees to bring a new machine if it is not banned by the government. Okay, government bans machines, books, and movies as per their decision. So A says, okay, I'll bring a new machine to you only if it is not banned by the government. If there is a ban on the procurement of that machine, I will not be able to. But if the ban is lifted, the ban is the contingency. If there is no ban, machine will be there. In the earlier example, if it rains, this is the positive thing. If it rain happen, then the good will happen. Then the good will be available. If the event does not happen, if the ban is not there, if ban does not happen, then machine would be there. These are the examples of contingent goods. Okay, it's always a future sale. So contingent and future goods are always, sale is a kind of agreement to sell. Sale is usually existing goods. Now we'll read about delivery, its forms and derivatives. What is a delivery? What are its forms and derivatives? Delivery means voluntary transfer of possession from one person to another person. Delivery means voluntary. It has to be by choice. Okay, it has to be by free will. Because delivery may happen by theft as well, by force as well. Okay, you can put a gun on someone and ask him to deliver. That kind of delivery is not contemplated in the Sale of Goods Act. Okay, delivery has to be free will, free choice, on volition. Okay, this is, we are not discussing about a delivery which is not voluntary. Okay, which is involuntary. Okay, delivery means a voluntary transfer. Transfer. Okay, transfer means thing is going from one place to another place. Okay, property is going from one place to another place, place A to place B. Voluntary transfer of possession. Possession, not ownership. Possession. Possession only, not ownership. Okay, delivery means voluntary transfer of possession from one person to another. Possession only, not ownership. That means even a non-owner can make a valid delivery of goods. Okay, even a non-owner can make a valid delivery of goods. Someone who's not an owner, even then he can sell it. A non-owner can also sell something. Maybe shocking to you, might be appearing shocking, but we will discuss it as we proceed ahead in the chapters, that even a person who's not an owner can also conduct a sale, a very valid sale. As a general rule, delivery of goods may be made by doing anything which has the effect of putting the goods in the possession of the buyer or any person authorized to hold them in his behalf. Okay, as a general rule, delivery will be made by doing anything, which has the effect of putting the goods in possession of the buyer. Okay, doing anything may be anything. Okay, it may be done by any number of ways. These are these three ways I've just told you. These are regular ways, usual ways, which are usually followed, but there may be some other ways of delivering something, delivering a good. Okay, delivery means, first of all, delivery. The basic delivery is delivered to the house or the office or any location specified by the buyer that I want this product at this particular place. Delivery is done. Or you keep it separate at a seller's premise, like we discussed in the example of 50 cotton bales. You earmark those 50 cotton bales and keep it separate. The delivery is complete. Delivery of the good is complete. Or putting in the cost of transport. Putting it in the cost of transport. I have to sell something from Mumbai to Delhi. So what I'll do, I have received the payment. Now what, I'll pack the product and put it into the transmission for the transport. Some delivery service provider will take it and deliver it to Delhi. I will definitely not myself go physically, someone else will go. The moment I hand it over to the delivery supplier, the delivery is complete. So delivery can take place in many ways. Okay, the only rule is delivery of goods may be made by doing anything. There is no specific thing provided by the act here. You can do anything which signifies delivery. Okay, which signifies delivery. You deliver a key of the car to someone. Delivery is complete. Car is still with you. Car is still with you, but you have delivered the keys. You have handed over the keys. Delivery is complete. Okay. Forms of delivery. There are following kinds of delivery for transfer of possession. Delivery of goods, voluntary transfer of possession by one person to another. Now there are three kinds of deliveries. First one is actual delivery. You are actually delivering something. Constructive delivery and then symbolic delivery. Okay, three kinds of deliveries are specified. Okay, they are actual delivery, constructive delivery, and symbolic delivery. Okay, first is actual delivery. What is an actual delivery? Actual delivery is when you actually physically deliver the goods to the buyer. When you physically deliver the goods to the buyer, when the buyer is having a final possession of the product, that is an actual delivery. Constructive delivery when it is effected without any change in the custody or actual possession of the thing, as in the case of delivery by atonement acknowledgement, e.g., where a warehouseman holding the goods of A agrees to hold them on behalf of B at A's request. Okay, this para may appear technical to you, but it's very simple. It simply says when constructive delivery means physical possession is not transferred. Physical possession has not been transferred, but ownership or the custody has been transferred. Ownership or the custody has been transferred. The example given here is okay. A's housekeeper holds a car belonging to A. Now A has a car, A has a housekeeper as well. Housekeeper is looking after the car. Now what A does, A tells to B that A tells to the housekeeper that car is sold to B. I have sold my car to B. Now do whatever B tells in relation to the car. Now with respect to this car, take further orders from the B. Now, if B says that burn this car, you have to burn this car. If B says deliver this car, you have to deliver this car. Or if B comes and say give this car to S or Y or Z, you have to hand over the car to S, Y, Z. That means the car is still then and there. The car is still where it used to be. It used to be in the A's house under the watch of his housekeeper. Sale has happened, but still the car is at A's house under the watch of his housekeeper again. But now the housekeeper is holding it for B. Earlier he was holding it for A, now he's holding it for B. So nothing has been done. Okay, not even a touch to the car, but the delivery has taken place. That is called a constructive delivery, where physical delivery has not taken place, but the delivery is complete. Okay. Other one is symbolic delivery. Third type of delivery is a symbolic delivery. When there is a delivery of a thing in token of a transfer of something else. Delivery of goods in the course of transmit may be made by handing over documents of title to goods like bill of lading or railway receipt or delivery orders, or the key of a warehouse containing the goods is handed over to the buyer. Okay, symbolic delivery means you have handed over the ownership documents. You have handed over the ownership documents, that's it. Okay, ownership documents are handed over. Now I want to buy a car. The car transfer has taken place. Okay, registry RC has been transferred in my name, but I still have not taken the car from you. That is a symbolic delivery. Keys are also with you. Keys are also with you. I only have got the RC transferred in my name. Right now, keys are with you, car is with you, but symbolically, the car has been delivered to me. Now the car belongs to me. Okay, so this is a symbolic delivery. Goods are said to be in a deliverable state when they are in such a condition that the buyer would, under the contract, be bound to take delivery of them. Okay, goods are said to be in a deliverable state when they are in such a condition that the buyer would, under a contract, be bound to take the delivery of them. Buyer cannot refuse to take the delivery. They are in a perfect finished condition. The buyer cannot refuse delivery. For example, when A contracts to sell timber and make bundles thereof, the goods will be in a deliverable state, because now what A has done, A has cut the timber, severed the timber from the land and made bundles of the timber. Now the goods will be deliverable. Goods are in deliverable state after A has put the goods in such condition. Okay. Now what A has done, A has complied with the conditions. Now the goods are in a deliverable state, and in this case now B is bound to take the delivery. B cannot now retract from his promise, and if the B retracts, it will be a breach of contract. Document of the title to the goods. Now what are the documents of the titles to the goods? Title, where we are using the word title as in ownership. Title means ownership. Who owns the goods? Okay, title is the ownership. So when we talk about title goods, title to the document of title means document of ownership. Who's the owner of the goods? Okay. It includes bill of lading, dock warrant, a bill of lading or a dock warrant, warehouse keeper certificate, a warehouse keeper's certificate, wharfinger certificate, railway receipt, multimodal transport document, warrant, or any order of delivery of goods, and any other document used in the ordinary course of business as proof of possession or control of goods, or authorizing or purporting to authorize, either by endorsement or by delivery, the possessor of the document to transfer or receive goods thereby represented. It's a very voluminous definition, but the only simple context of this definition is any document, okay, which shows the ownership, that is a document of title to the goods. Like suppose in the case of bill of lading, if I've loaded some goods on a truck or a train or a plane or a ship, I'll get a receipt will be signed by the whatever is the respective authority, for a truck owner or maybe a captain of the ship or the captain of the plane, okay, or the station master of the train. They will give me a receipt that you have put these many goods on the train. Okay, so now it's a bill of lading. The bill of lading shows that I have put those goods, these goods belong to me. So when the goods will reach on the next station, I can unload them by using that bill of lading. Okay, dock warrant. Dock means when some ship is going to come to the land, it's called dock warrant. So if I have a warrant with me that whatever is available in your ship, it belongs to me, it is the title. Okay, warehouse keeper certificate, wharfinger certificate, railway receipt, multimodal transport document, these are all title goods. Okay, and any other document. Now there may be so many documents, so it is not practical to write down all the documents in the definition. So it says any other document used in ordinary course of business. In ordinary course of business, if we are using any other document as a proof of possession or control of goods, as a proof of possession or control of goods, or authorizing or purporting to authorize, either by endorsement or by delivery, the possessor of the document to transfer or receive goods thereby represented. If you have such a document which is used in the business, which gives you authority to sell or to transfer the goods to further any other person, it becomes a document of title to goods. Example, bill of lading, doc warrant. Okay, it has been written here. However, there is a difference between a document showing title and a document of title. Okay, document showing title is a different, document of title is different. A share certificate is a document showing title but not a document of title. It merely shows that a person named in the share certificate is entitled to share represented by it, but it does not allow the person to transfer the share mentioned therein by mere endorsement on the back of certificate and delivery of the certificate. So document showing title, simply I say I have a RC of car. It is a document showing title. It shows who owns this car. This car is registered in my name, so I am the owner of the car. Okay. But is it a document of title? No, it is not a document of title. What is the document of title in relation to a car?
It's 11 o'clock.
Okay, car transfer certificate as per government rules. That is a document of title. Mercantile agent. Now, another definition is mercantile agent. Who is a mercantile agent? It means an agent having mercantile means commercial. Mercantile agent. It means an agent having in the customary course of business as such agent authority either to sell goods or consign goods for the purpose of sale or buy goods or to raise money on the security of goods. Example of such kind of agents are auctioneers, factors, or brokers. Okay, someone who's in charge of conducting an auction. Okay, he is a mercantile agent, factor, or broker, property brokers. If I want to rent out a flat or if I want to buy some property, I'll go to a property broker, I'll go to a property dealer. He has the keys of the house. Okay, he'll show me the house and he can definitely sell it to me because he has authorization from the owner. Okay, or salesmen or saleswomen come to our houses bringing different products, that we are selling this product, we are selling that product. They are not the owner of that product. They are holding those product as an agent to the owner. Owner is somebody else. Okay, owner is somebody else who has sent those people as an agent to go door to door and sell its product. So they are mercantile agent. They can deliver you the product. If you want to buy a product from a salesman, okay, from a Raymond showroom, he has come to your house. You need not to go to take some authorization from the Raymond owner, Raymond's shop owner. The mercantile agent, that salesman, has the authority because he is mercantile agent. He can validly sell it to you there, and the transfer of the ownership transfer made by the mercantile agent is a very valid ownership. You do not need to go to the owner at all. Property here means ownership of Property here means ownership or general property, ownership of general property. Okay, property here means ownership or general property. Okay, your ownership is also a property. In every contract of sale, the ownership of goods must be transferred by the seller to the buyer, or there should be an agreement by the seller to transfer the ownership to buyer. Okay, it means the general property right to ownership in goods and not merely a special property. Okay, the property in goods means general property. Okay, the property in goods means general property. All ownership rights of goods. Okay, all ownership rights of the goods. Like if I buy a mobile phone, okay, I have all ownership rights of the goods. If I buy a mobile phone, I can use it for making calls. I can use it for accessing internet. I can use it as a spare phone. I can give it to my mother. I can give it to my friend. I can sell it in the market. I can put a different cover over it. I can draw something over it. I can get it customized. I can destroy it. I can just keep it in my drawer. Okay. I have a complete ownership. Okay. I have complete ownership with the mobile. Whatever I wish to do with the mobile. Okay, whatever I wish to do with the mobile. It is not that you have only special rights, that you get a mobile only to make a call, and you have to return it later if you are not using it to make calls. Okay, so property in good means general property. I have a property in mobile means I have a general property in mobile, all ownership rights of the goods. Whatever this mobile is capable of doing, I can do all those stuff. Okay. Note that general property in goods is to be distinguished from a special property. Some properties are special property. It is quite possible that a general property in a thing may be in one person and a special property in same thing may be in another. Okay. When an article is pledged. Muthoot Finance. Okay, Muthoot Finance, what does it do? I go keep my gold with the Muthoot Finance. Muthoot Finance will give me money. Now, who's the owner of the gold? I am definitely the owner of the gold. But who has the gold right now? Muthoot Finance has the gold right now. Okay, Muthoot Finance is keeping it in his gold, okay, in his own locker. So Muthoot Finance has a special property. in the gold. What is the special property in the gold? Special right to have the gold right now till the time I have not repaid the mortgage. Okay, but who's the owner? Who's the general property owner in the gold? I. Okay, the general property in a thing may be transferred subject to the special property continuing to remain with another person, the pledgee, who has a right to retain the goods pledged till payment of stipulated dues. Okay, so if I have a right to put my gold with Muthoot Finance. Okay, now I have put my Muthoot Finance with someone else. Gold with Muthoot Finance. Muthoot Finance now has a special property in good. Okay, meanwhile I sell my good to someone else, and he agrees to repay my mortgage. So general property is transferred, but the special property is still with Muthoot till the time repayment is not made. Gold will not be released. Example, if A, who owns a certain goods, pledges them to B, pledges means keeping the goods as a security and taking money over it. A has a general property in the goods, whereas B has a special property or interest in the goods to the extent of the amount advance he has made. Now, another definition is insolvent. A person is said to be insolvent when he ceases to pay his debts in the ordinary course of business or cannot pay his debts as they become due, whether he has committed an act of insolvency or not. That means a person who is unable to discharge his financial obligations, who is unable to repay his creditors, is an insolvent or a bankrupt person. Price means the money consideration for the sale. Okay, whatever we pay for buying something or buying some property, that is price. So we are done with the definition part.